Hi, this is Mayor Pete. I'm here in the office of the mayor, and I'm with our town attorney, Randy Dibella. Over the last several days, I've had lots of phone calls, emails, also on social media, a lot of people talking about the municipal budget vote and the fact that we as residents, including myself, don't have the ability to vote this year. One of the things that we did when we did get this executive order is I sat with our town attorney, Mr. Dibella, also voter registrars, and thought about a way. Could we do this through the mail, do a mail-in vote? So I'd like to turn this over quickly to Randy to kind of give you kind of the timeline and logistically, when we started looking at that, what happened. So Randy.
Sure, certainly, Mayor. Hello. During the course of this entire event, there were executive orders that were coming out multiple times a day. And at the time that this one came out, this one, the one I'm referring to, is 7-I with subsection 13. The mayor and the registrars, both registrars and I, were literally on the phone talking about how to accomplish a mail-in vote. Now, a mail-in vote is not ideal without protocols. So that's what they were working on. We were expressly talking about that. The next day, we caucused. When I say we, I'm talking about the Connecticut Association of Municipal Attorneys, and there was a discussion concerning the content and the substance of this order. Bear in mind, an executive order is the force of law. It's just like a statute. During a time of emergency, it's absolute until such time as it dissolves or some judge reverses it. Now, the reality here is that what the governor said is he said, notwithstanding, which means irrespective of, doesn't count, any charter provision or ordinance, then the budget process will be as outlined in this particular order. The claim that you can have a write-in or a mail-in based upon this order is absolutely false, untrue. You cannot have a write-in because what the governor said in his order is that the budget will be approved by the budget-making authority without holding votes. That means any vote is precluded. And that's the consensus of those who know what they're talking about, and that would be the Connecticut Association of Municipal Attorneys. That provision is incredibly revolutionary. Why? Because it does away with the citizens' vote on the budget, and it's mandatory. The process will be, and the process has been, that the mayor takes a budget to the town council, which has its hearings and deliberations, and sends it to the Board of Finance. The Board of Finance does what's known as a bicameral review. They also review it, and they have their hearings. Then they make their adjustments of only 5 categories, major categories, sends it back to the town council for further review and a potential veto session. That's how it stops now. What we usually do is all those procedures, and then it goes to an informational town meeting, and then a referendum. The referendum is the vote. That's been dispensed with by this order. And it's not a suggestion, it's an order.
And so, Randy, a lot of people think that the town of New Milford can kind of do what it wants, that it can hold its own meeting irregardless of this executive order.
And that's absolutely false. And the reason for it is because this is designed to avoid an event of congregation. The order says shall. It's in mandatory tenor. There's an advisory that I've given the town council and his honor that's in the mayor's office that will explain how this works. And it'll explain it in no uncertain terms. There's no punches pulled in that.
And we'll be posting that, Randy, on our town website. So you'll be able to see this, what Town Attorney Dibella is talking about.
And again, this is not me and my experience. This is many, many experienced municipal lawyers, the best municipal lawyers in the state, who came to this conclusion based upon our discussions and our listserv information. This includes Danbury, West Hartford, New Haven, Wallingford. I mean, these are experienced municipal lawyers. It includes the 4 municipal lawyers in my firm. And this is advice that's been given statewide.
And Randy, people may interpret this because of the heading in the newspaper article, that this is just New Milford. If you could let everybody know, this is municipalities that have the same form of government as ours. It's all of them, correct?
169 of them. Now, some of them don't have a town meeting vote. Some of them don't have a referendum. Some of them, their town council or their city council does this anyway. So that wouldn't apply to them. What would apply to them is they're not allowed to have congregating town meetings and events to discuss it. But they don't have, some of these towns don't have referenda. So that's not a big deal to them. But it is to every other town that does, because referendums are excluded, absolutely by order. And there's no court, by the way, to go to reverse it. Secondly, as a municipal lawyer, and any lawyer who took an oath, cannot counsel their client, their municipal client, to violate it. That would be a violation of the attorney's oath to uphold the Constitution and to provide good, sound legal advice to the best of her or his ability. So as much as I hate this, as much as the mayor came through the phone at me when I told him about this, this is not something that we can do in a lawful society. We have to follow the law. Having said that, the mayor decided to write a letter to the governor. And as a matter of fact, I'm going to also send a copy of that to the governor's council attorneys concerning a request, a special request to waive the preclusion of a write-in ballot. And this was, to your knowledge, you need to know that this was the mayor's intent all along, is to make sure that there would be a vote. Again, I cannot counsel any of my towns, including New Milford. I cannot counsel any of them to violate this order. And I hope you understand that. I hope you understand this is not something that anybody in government relishes, anybody reasonable relishes. In fairness to the governor, which is not a happy thing to say for Republicans, in fairness to the governor, he's dealing with a situation that is floating upon uncharted waters. And we don't know what rocks and shoals are beneath it. I've said that many times to a number of my municipal clients. So we would ask you to please bear with the fact that we're trying to comply with the law to the best of my oath and to the best of our ability, and the mayor's oath. And we'll continue to do that. Any changes, and we're up to date to the moment on the executive orders, any changes that are to our favor or are not favor will be on.
And Randy, we had a candidate that's seeking our state Senate seat here in New Milford and all the way up the northwestern part of the state here, who's been opining that you actually can do a mail-in writing. And again, as we said before, just so everybody understands, we cannot do it per this order of the governor.
You cannot do it per this order of the governor. This is not Mayor Bass. This is advice that I've given. I represent a number of towns up and down the Northwest Hills. All of them I've advised to ignore that. It's wrong. You cannot play with fire. The consequences of doing that, the mayor asked me what the consequences would be, because he was tempted to defy the order, frankly, and I don't think I'm breaching a confidence. And the consequence is that the vote would be a nullity. It was my opinion and the opinion of 7 of my colleagues on the Connecticut Association of Municipal Attorneys, who are not my partners, that if the town decided to do a write-in vote or any other type of vote, that in the face of this, it would be void. So it would be an exercise in futility and the ultimate condescension to the constituents. Can't do it. A defiance is not right. An off-the-wall interpretation in order for a political advancement is absolutely not correct either. If a write-in ballot was permitted, the governor would have said that in the executive order, just like a statute. When the legislature passes a statute, if they meant something to be, they would have said it within the context of the control. That is not true. It is not correct. I will not opine, and I will not certify a result that way. Put that to sleep.
Thank you, Randy. And so you may be thinking, well, what can I do? How can I show my opinion in what we have? Really, the guidelines that have been bestowed upon us by the governor. What we can do is voice your opinion with the process that we have. Tomorrow, Saturday, the Board of Finance is having their public hearing. Please call into the virtual meeting and let the board know your opinion on the budget. It's very important. They will then next week, next Wednesday, they will then be doing their assessment of it and doing their recommendations. Once that's completed, they will then send it back to the town council. I'm going to be asking for the first meeting in June to be the meeting where the town council discusses the budget. Why? To give them plenty of time, ample time, for you, the public, to opine to them. You can do that via letter, via email, phone call, however you'd like to do that. It's important for all of us. And also, if you could contact the governor's office, because it's the governor's executive order that put us where it is today. Not New Milford, not the town attorney, nor any other municipal towns. It was the governor's executive order. So I ask that you call the governor's office, email or write to him, and ask him to either amend his order or to give us a waiver. Because I'm a firm believer, as you are, that you have the right, the ultimate right, to decide the budget here in New Milford. I'll be talking more about this later, but I wanted you to know straight from our town attorney, not from anybody else, exactly how the process is. I again thank you. Let's all continue to pull and work together, especially during these times. God bless you. God bless your families. Thank you.